The United States government has initiated a significant legal battle against one of the nation's largest cities. A civil lawsuit was filed yesterday against the city of New York and its mayor, Eric Adams, aiming to dismantle the city's sanctuary jurisdiction laws. The lawsuit specifically calls for the overturning of provisions within the city's administrative code and police directives that limit cooperation with federal immigration enforcement. The Department of Justice argues that these local policies are in direct violation of the Constitution's Supremacy Clause, which establishes that federal laws take precedence over conflicting state and local laws. This legal action represents a major step in fulfilling one of President Donald Trump's most prominent and long-standing policy goals. Throughout his 2024 campaign and his administration, the president has vowed to end the practice of states and municipalities refusing to cooperate with Immigration and Customs Enforcement, or ICE. New York City, with its significant left-leaning electorate, has long been a bastion of opposition to federal removal operations, particularly for foreign nationals who have not committed other crimes since their illegal entry or visa overstay. The city has codified these protective policies, which expressly prevent the New York Police Department from assisting ICE in matters of identification, detention, and removal. The federal government's lawsuit now seeks to have these policies declared unconstitutional, setting the stage for a high-stakes confrontation over immigration policy, states' rights, and federal authority. In another move reflecting the administration's fiscal priorities, President Donald Trump signed a bill on Thursday to claw back $9 billion in previously approved federal spending. The president celebrated the bill's arrival on his desk via a post on Truth Social, calling the move big. The largest portion of this rescission package targets foreign aid, canceling $7.9 billion in funds that had been appropriated for the U.S. Agency for International Development. While USAID's primary responsibilities have since been integrated into the State Department, these appropriated funds remained on the books and are now officially canceled. The second major cut in the bill eliminates $1.1 billion for the Corporation for Public Broadcasting. This is the federal entity responsible for providing financial support to both National Public Radio, or NPR, and the Public Broadcasting Service, known as PBS. This defunding action follows years of criticism from conservative voices and the Trump administration, which have frequently accused both public media outlets of exhibiting a persistent liberal bias in their news coverage and programming. It is worth noting that the bill was originally larger. An initial proposal to cut $400 million from PEPFAR, the president's emergency plan for AIDS relief, was ultimately stripped from the final legislation. This preserved funding for the widely supported State Department initiative that combats HIV and AIDS abroad. Turning now to a high-profile legal case directly involving the president, a federal judge has ruled that Ryan Ruth, the man charged with the attempted assassination of President Donald Trump last year, can represent himself during his upcoming trial. The decision was handed down on Wednesday by U.S. District Judge Aileen Cannon. While granting Ruth's request to act as his own attorney, Judge Cannon also ordered that his court-appointed lawyers must remain on the case as standby counsel. This means they will be available to offer legal advice and assistance should Ruth request it during the proceedings. The ruling follows a motion filed earlier this week by Ruth's federal public defenders, who had asked to be formally removed from the case. In their court filing, the lawyers stated that their client-attorney relationship had broken down, citing that Routh had refused multiple requests to meet with them to prepare a defense strategy. Routh, who is 59 years old, is accused of a brazen assassination attempt that took place in September of 2024. Prosecutors allege that he positioned himself with a rifle on the grounds of the Trump International Golf Club in West Palm Beach, Florida, and opened fire in an attempt to kill the then Republican presidential nominee. His trial is scheduled to begin this September, which will mark the one-year anniversary of the alleged attack. In other news from the judiciary, the Supreme Court has issued a significant, if temporary, order concerning the landmark Voting Rights Act. On Thursday, the nation's highest court intervened to pause a controversial lower court ruling. That ruling had effectively prevented private citizens and groups in 7 states from filing lawsuits over alleged voting discrimination. The decision came from the U.S. Court of Appeals for the Eighth Circuit, which had issued a novel interpretation of the 1965 Voting Rights Act. The appellate court concluded that only the United States Attorney General had the authority to bring lawsuits under Section 2 of the Act, a key provision that prohibits voting practices or procedures that discriminate on the basis of race, color, or language minority status. This interpretation would have barred private individuals and civil rights organizations from bringing their own challenges. The Eighth Circuit's jurisdiction covers Arkansas, Iowa, Minnesota, Missouri, Nebraska, North Dakota, and South Dakota. The Supreme Court's emergency order, which was unsigned and did not provide any detailed reasoning, puts the Eighth Circuit's decision on hold. The case, known as Turtle Mountain Band of Chippewa Indians versus Howe, will continue to be litigated. For now, this action by the Supreme Court ensures that the courthouse doors remain open for private plaintiffs in those 7 states to file lawsuits to protect their voting rights under federal law. And finally, in the world of business and media, a multi-billion-dollar merger has received a green light from federal regulators, but it comes with some notable strings attached. The Federal Communications Commission has officially approved the $8 billion merger deal between Paramount Global and Skydance Media. Paramount, the parent company of the CBS television network and numerous other media properties, will now be acquired by the growing production company Skydance. The approval was announced by FCC Chairman Brendan Carr on Thursday. In a post on the social media platform X, Carr, who was appointed by President Trump, explained that the approval was granted after Skydance made what he described as significant new commitments. According to the FCC chairman, these commitments include pledges to address perceived bias and restore fact-based reporting, to end certain diversity, equity, and inclusion practices, often referred to as DEI, and to make substantial investments in trusted local news. The agreement specifically includes a $1.5 billion investment into Paramount to bolster its operations, with a particular focus on funding for local news and broadcast stations. In an extended statement, Carr noted that many Americans no longer trust legacy national news media, framing the deal's conditions as an important step towards earning back Americans' trust. He concluded with a direct warning to the company's new leadership, stating that the FCC will be watching.